I have no idea why any of you people are taking this course with Vince. Everything he's learned from me. I mean, seriously, paying that hard, good earned money to listen to him, there's no better money well spent. Folks, what's up, advocates? As Vince would say, I'm David Farber, and I am your insurance attorney. Little background about myself. I've been practicing law a little over 20 years. First 7 or so years of my career, I represented the insurance companies. So I know how they think, I know how they operate, and I know how to get the best result by exploiting their weaknesses. For the last 13 to 14 years, I've been a plaintiff's lawyer, only representing policyholders in their pursuit of justice in obtaining positive results from the insurance company. And I believe, not to brag, that my win-loss ratio is probably 97-98% in terms of turning cases into money. And part of the reason for that is because I tend to work with good public adjusters who know what they're doing and know how to get a case from A to Z.
Listen up, advocates. Whether you're a public adjuster, contractor, or an attorney, if you have a client that has suffered any kind of catastrophic loss, whether that be by fire or storm or just any catastrophic loss that requires your client to have to move out and incur ALE and loss of use coverage, you need to think about looking at Black Diamond Services. This is an incredible idea for a service that I think is extremely valuable, and I've actually personally used for my clients myself. Basically, what they do is they provide all of the necessary money that is needed to be done for the homeowner to go and move to another place, whether that be a hotel or another home or whatever it is. They basically bill through their insurance policy's loss of use coverage, and basically they provide financial assistance so that the insured never has to incur any out-of-pocket expenses. It's an amazing service. I love the people at Black Diamond Services, especially Millie Varela. If you just contact her and contact Black Diamond Services, I'm telling you, they're going to take care of your clients like you wouldn't believe. I personally have a client who suffered a fire damage and had to use their ALE coverage, and all we did was refer them to Black Diamond. Our clients did not have to come out of pocket a single penny. Black Diamond provided all of the financial money, and they provided the actual location for the homeowner to stay. Amazing service. Contact Black Diamond Services today so you could find out more information for yourself.
So what are we going to talk about here today? I'm going to talk to you a little bit about what an attorney needs to see in a file so as to be able to properly and appropriately represent an insured in a court of law. Now, part of this is going to be associated with what you do in what we call pre-suit, and the other aspect of this is what's going to be thought about as it relates to what happens at trial in terms of the types of questions or issues or problems that are going to come up during a trial, so as to make sure that you are as properly as prepared as you possibly can be. So, certain aspects of a case start from the day that you get hired. In fact, most, if not all, of your evidence will be gathered on that particular day. So, depending on how you obtain your client, whether it be through the internet, through word of mouth, through a flyer, whatever the case may be, you want to make sure that you document how you first came in contact with that individual, because undoubtedly you will be asked that in a deposition, and they want to establish that either there's a course and scope of some sort of prior relationship, or that this is a new, fresh relationship which has only blossomed because of the fact that they called you because they needed your assistance. And you, as a public adjuster, are in no more nobler profession than I can think of than, in fact, an attorney. Because what we do and you do is you stand up and you give a voice to the little guy against the big giant insurance company. Nobody's going to do it but you, me, and the chosen few. So I tell you this, once you get that client, you're going to want to make sure that you go there and you properly document that loss. What does that entail? Well, bring a camera with you. It's clear as day. Take as many photographs as you possibly can, and especially of the damage. And should you have water or something active ongoing, make sure to document that in both video format as well as in a photograph. That is going to be very useful to you when the insurance company is arguing some sort of defense, whether it be repeated leakage and seepage over a period of time or some other defense like pre-existing damage. Whatever it may be, you're actively addressing the issue then, okay? When you're there, bring your moisture meter. If you don't have one, buy one, okay? If you're dealing with a water loss, you certainly want to make sure that you can document that you put the water meter down and you took a picture, and that it had elevated high readings of moisture. That will be instructive and assistive to the insurance adjuster in being able to determine if you have an active ongoing problem in that home, which you're otherwise helping your insured to document and be able to establish the cause of the loss. So now you're there and you're taking scope notes, okay? Most of you aren't going to go out there with an iPad and try and create your estimate while you're there. It's just too difficult to do it. But when you take these scope notes, it's a good idea for you to keep them in your file, because if they ever ask you during your deposition, how did you determine what you were going to write, you could essentially, if you wanted to, recreate your estimate from using the same scope notes that you took on that day. So you are in a much better position to be able to answer that question that is posed to you from a lawyer when he's trying to discredit your estimate and why you chose certain things in the home. For example, you can't just put damaged cabinets. You need to know what grade of cabinets they are so as to make sure that you choose the correct grade when you're ultimately filling out the form, as well as the Xactimate or SimSol or whatever software you use in order to create that estimate. So now you're there, you're talking to the insured, and they're giving you certain information that's very useful, okay? You may want to jot that down, and you may want to be able to refer back to it, so when the insurance company asks you in deposition, what did the insured tell you? You can specifically say, she told me, he told me that. And that way there's no dispute, and you're not relying upon your memory when push comes to shove and say something that could potentially be problematic. The other thing that you may want to consider, depending on the size of the loss, is potentially bringing an attorney in early on. Why do I say that? Well, the insurance company unfortunately tends to give more, or fortunately, more credence when an attorney is involved versus a public adjuster. The reason for that is because we can sue them whenever we feel that they are not doing the right thing as it relates to our client. You, on the other hand, can continue to push and knock on the door and bang as loud as you possibly can, but sometimes they just won't listen. So in circumstances where you've got a big loss and you need that extra muscle, consider contacting an attorney, perhaps myself, who may be willing to sign on the case early on at a much lower percentage, with the knowledge that we're going to be able to preserve and assist the public adjuster, you, in making sure that the case is as well thought out and addressed as it possibly can be, so that when we get tired of the insurance company messing around, we're in the right and exact position to be able to file a lawsuit right then and there. And at that point, you're not scrambling potentially to find an attorney or trying to make sure that the file meets what the attorney wants it to meet. The attorney already helped you create the file. And as we all know, more likely than not, the insurance company is not going to pay you or your client the full amount of their loss so as to ensure proper indemnification. And ultimately, that case is going to end up in litigation, because a very good public adjuster is the one who never quits. Okay? The one who makes sure that at the end of the day, if there's a fight, they're willing to take it to the insurance company. And the only way that that's going to happen is if you're with a good, strong attorney who's got your back, and more importantly, has your client's back to make sure that they receive what they are entitled to under their policy of insurance. It's not fair, as you know, to pay your premium and not get the benefit of the bargain with some sort of technical policy language that is more likely than not applicable to your particular loss or ambiguously implied. And an attorney can assist you in determining that policy language, which is why when you're out at that loss, you want to obtain that policy of insurance. You want to know what limitations there are. You want to know, are there exclusions? You want to know how to best frame the potential loss so that when you meet with that field adjuster from the insurance company, you don't say something that is going to be problematic to your case. And of course, when you start using this type of language around your client will be much better prepared to call something per se a pipe break as opposed to a leak in a recorded statement. And the reason for that, of course, is because the insurance company doesn't want to pay for things that happen for a repeated leakage and seepage type situation that occurs over a long period of time. They want to pay for a sudden and accidental loss. So people just say, I had a leak, because they don't think about it. But you as a public adjuster, you know better. And you know that your client doesn't. And so it's your job to educate them through the use of Vince's course and your own knowledge and experience as to what their loss really is and how it should be properly explained, because it's the truth. And you want to make sure that the truth is conveyed in a way that ultimately is best for the client and for his or her case. So now you're at the loss. You've now taken your scope notes, you've taken your photographs, you've taken your measurements, you've got your moisture meter, you've taken those photographs, you maybe have documented the exact evidence, you've spoken to the client, you've gotten his or her account of what exactly happened. What do you want to make sure that you do? Well, at this point, you want to report that loss as quickly as humanly possible. Okay, as everyone knows or should know, every insurance policy is going to have a prompt reporting requirement of some sort. That prompt reporting requirement isn't necessarily, actually it's never quantified in terms of an amount of time. It says reasonable or prompt or something along those lines. That's, subject to interpretation. Whose interpretation? Unfortunately, the insurance company is going to say their interpretation. So they may ultimately believe that 1 month, 2 months, 2 weeks, 2 days is not prompt notification. Of course, that would not be true in most sense, because homeowners or commercial policyholders, they don't necessarily know what their policy says. And more importantly, they don't know what prompt reporting or reasonable reporting is. And really, the courts are the ones who potentially determine that. And thankfully, in most courts, depending on your jurisdiction, it will determine based upon the facts of the case. Meaning when the insurance company cries, boo-hoo, you didn't give us notice in enough time, the jury is going to have to determine whether or not that notice was proper under the circumstance as to what the insured knew or didn't know at the time, and whether it caused any type of prejudice to the insurance company. So put the insurance company on notice as quickly as possible. Now that you put the insurance company on notice as quickly as possible, get your estimate completed. Do so as thoroughly and as appropriately and as timely as you possibly can, okay? Upon completing that estimate, you want to fill out a sworn proof of loss. Even if it's not requested, make sure that you have your own, and make sure that you use it, because many states, including Florida, necessitate that an insurance company respond in a particular amount of time, so to ensure that they pay or they deny a claim. So some states have prompt payment statutes. Other states, like Florida, has a 90-day statute which imposes an interest penalty should the insurance company not pay or deny the loss within 90 days. Now, that doesn't necessarily mean that they have a full 90 days to inspect or make a coverage determination, but rather that's the outermost bounds as to when they can do something before they get penalized for an additional amount of money, that being interest. So when you report that loss, I always view it as the concept of righteous indignation, which is, insurance company, why is it taking you so long to do what is required? My client is sitting there with a burned out house, a flooded house with sewage, a hole in their roof, whatever the case may be. Please explain to me why it has taken you a week, 2 weeks, 3 weeks, 2 months to make some sort of coverage determination when your insured is suffering. Okay? And if you have that philosophy and you look at cases like that, you're going to start peppering, or you should pepper the insurance company with letters. And the letter should be is, we're making ourselves available to you. Please come out as quickly as possible because we do not want our client to suffer needlessly. And respectfully, you need to know, as much as the insurance company needs to know, that that client actually is both yours and the insurance company's. We think of it as an adverse relationship because unfortunately, so many of these things do end up in litigation, but the insurance companies have an obligation to their insured, just like you have an obligation to your insured. And both of you, if you're doing the right thing, are trying to make sure that the insured is paid appropriately and properly under the insurance policy. So the insured is both of your clients. But sometimes the insurance company forgets. It's kind of like when you go to a bank and you say to the bank, I'd like to withdraw money. And the bank looks at you and they go, well, that's not your money, that's our money. And you're like, wait a second, I paid a premium to be able to keep money at this bank. And now all of a sudden, when I need it, you're like, nah, you got to pry it out of my cold, dead hand. Well, folks, that's just not appropriate. And the commercial claims advocate is teaching you how to make sure that the insurance companies don't railroad folks, because at the end of the day, they're doing a disservice, not just to your client, not just to the industry at large, but to everyone in your community. Seeing homes with blue tarps devalues neighboring property. Seeing homes with roofing tiles that are mismatched because the insurance company was too cheap to pay for a replacement roof devalues property values in a community. You can go down the list of when an insurance company doesn't properly pay, it ultimately reduces the value of someone's home that they'll receive less money for when they potentially sell the house or the commercial property because it has an insurance loss and it was not properly indemnified. And that's why you're here, to make sure that there is proper indemnification. So now, you've already documented your loss. You prepared your sworn proof of loss. You've submitted your estimate to the insurance company. Now is the time to put the pressure on. Now you want to start writing your letters. If you want to conduct an expert or send an expert, send one. If you want to do a reinspection, do one. If you have any post-loss compliance you want of my client, ask me for them now, because if you do not ask it of me now, I'm going to assume that you don't otherwise need any further post-loss compliance, and therefore my client has satisfied everything he or she is required to under the policy. Because once you've done everything you can or should do under that policy so as to get your client paid, why is the insurance company just sitting there taking its sweet time to make a determination? Which is why you send those one letter or one line emails that simply say, it has been 2 weeks since you performed your inspection. You have not admitted or denied this loss. We anticipate that you will do so within the next 5 to 10 days. We do not want our mutual client to needlessly suffer for a covered loss. Then, if they don't respond, what's the next thing that you want to have happen? Send out another letter that says, if you do not provide us with some sort of coverage determination and stop this needless suffering, we may be forced to seek legal counsel so as to protect our rights. And at that point, the insurance company just looks foolish when they go into court and they ultimately have to explain their actions when a judge says, what were you doing, insurance company, for the past month or week or however long, 6 months, okay? I've said it before and I'll say it again, okay? Getting an expert involved, while it may cost you some money on the front end, will ultimately save you money on the back end from having some sort of improper denial, okay? But you have to be careful as to the experts that you hire, because just like saying the wrong thing to an insurance company, if you don't review a policy and you don't know what the actual loss is or how the loss was caused or whether it falls within or outside of coverage, an expert can do the exact same thing. Far too often, if there's no attorney involved or there's no public adjuster involved, somebody will just go hire an engineer because they think that that's what they should do. And guess what they do? They knock themselves right out of coverage. A guy called me the other day, past client, and he says to me, hey, I had an insurance loss denied. And I said, okay, you should have called me before that happened, but okay, we're here now. What happened? Well, this, that, and the other thing, and I hired an engineer. I said, okay, that's good. So you have an engineering report supporting your case? Yes, I do. I go, well, we haven't sent it to me yet, but give me the gist. And he says, well, it more or less says that the roof was defectively installed and that it failed and ultimately the interior got damaged. I said, well, that's nice. I'm like, but there's no such thing as a covered peril associated with a defective roof, okay? There's an ensuing loss aspect of things, meaning that the interior damages, depending on your policy, may be covered, but the roof certainly is not going to be covered if the roof was defectively installed, as now supported by your actual engineer. And maybe this engineer isn't the type of engineer who does this type of work and thought he was actually helping the insured when he wrote that engineering report. And of course, if it's the truth, then it's the truth, and you can only work with what you've got. But making sure that you reach out to the proper individuals, be it an attorney, proper experts who understand these issues, or other similar folks in your industry who are your peers to assist you in these type of things is critical. I can't tell you, how many times if I have an issue, I contact someone I trust and appreciate their thoughts in being able to pursue my claims, because it's good to be able to bounce ideas off people to make sure that you're in agreement. Because if we learn about how to best handle these claims together, we won't create bad case law. Because the worst thing about people, and Socrates said something to the effect of, smart people are those people that learn from everything and everyone. Average people are people that learn from experience, and smart and dumb people are those people who believe that they have all of the answers to begin with. Okay? And those people, unfortunately, do practice law. And they will run into a glass shop like a bull in a china store and ultimately create bad law that will negatively impact our cases in the future, where our clients are going to be looked at through that case law, which is ultimately going to be potentially problematic. So there's a lot more that I can get into, and I'd love to talk to you more. I'm David Farber of the Farber Law Firm. You can follow me at Farber Law on Facebook, as well as on Instagram. You can reach me at 305-774-0134. You can check out my website at www.thefarberlawfirm.com. And remember, advocates, keep fighting, keep moving, and keep doing what you do best, giving a voice to the underdog and kicking insurance companies' ass. Take care, and thank you, Vince, for letting me be part of your awesome organization. Thank you.